Hello everyone. In this video, I'll explain 10 important topics under constitutional law of India. The first one is public interest litigation, that is PIL. When we say that courts in India are open to everyone, that is true in theory, but in reality, not everyone who suffers injustice can actually go to court. Many people don't have money, many don't know their rights, some are scared of authorities, and because of this, a lot of genuine problems never reach to the courts. Now think about the situation. A factory is polluting a river. Hundreds of families are affected. That may be health problems or drinking water problems or anything in that matter. But not a single person files a case. Should the court say no one has come, so we will do nothing? Of course not. This is where public interest litigation becomes important. Public interest litigation or PIL is not about personal disputes. It is about issues that affect the public or a larger section of the society. The most important thing you must remember this. In PIL, the person who files the case does not have to be personally affected. Any public spirited person can approach the court. The idea here is very clear. Justice should not stop just because the victim cannot fight. Courts have gone one step further. They have relaxed technical rules. In some cases, even letters sent to judges were treated as pills. So we no need to approach the court directly. Even if we send any letter in that matter, the court or judges will treat them as public interest litigations. That tells us one thing very clearly. In PIL, justice is more important than the procedure. So whenever you hear the term PIL, don't think of it is a complicated legal concept. Think of it is a bridge between courts and common people. Now let me quickly connect this with what is written on this slide. Public interest litigation means a case filed for the benefit of the public at large section. It can be filed by any public spirited person. Its purpose is to protect the rights of poor and disadvantaged sections. Any procedural rules are relaxed to ensure access is justice. Now we will go to the second question, that is gender justice. And before anything else, let me clear one very common misunderstanding here. Many of us think immediately that the gender justice means it's only women rights. That is not completely correct. Here, the gender justice actually means the fairness and equality for all the genders. It is about making sure that a person is not correctly treated just because of their gender. Now think about the society for a moment. For a very long time, men and both women both have not been treated equally in education, in jobs, in safety, in decision making. There has always been imbalance. If the law was simply said everyone is equal and nothing did, that inequality would have continued even now. This is why the Constitution actively supports the idea of gender justice. We need to remember Article 14, 15, and 21 in this. The Article 14 talks about equality before law, and the Article 15 talks about state shall not discriminate. Article 21 talks about living with dignity. When we put these three together, we get an idea of the gender justice. Gender justice does not mean giving unnecessary advantages. It means removing disadvantages that already exist. For example, if women are not safe at workplaces, they will not go to the work, they will naturally stop participating. Laws against sexual harassment are made so that women can work freely and safely. So, gender justice is about creating equal conditions, not special treatment. Now, let us align this with what is written on the slide. Gender justice means fair and equal treatment for all the genders under the law. It is based on Article 14, 15, and 21 of the Constitution. The objective is to remove discrimination and ensure dignity and equality. Now let's look at natural justice. This is the third question. This is one concept where students often remember Latin words but forget the actual idea behind it. So let's forget the terms for a moment and think practically. Imagine this situation: you receive a notice saying you are punished, but nobody asked you anything. Nobody heard your side, and the decision is already taken. Naturally, the first thing you will say is, "This is not fair." That feeling of fairness is exactly what natural justice is about. Natural justice simply means that any decision affecting a person should be taken fairly. It is not about technical rules, it is about basic human fairness. Now, natural justice mainly works on two very simple ideas. Here we need to remember these two ideas. The first one, listen to the person before deciding. The second one, the person deciding should not be biased. These ideas are so basic that we expect them everywhere, be it in a courts, in a offices, in colleges, and even in workplaces. Natural justice applies not only to judges but also to administrative authorities and disciplinary bodies. Whenever a decision affects someone's job, reputation, or rights, natural justice must be followed. Only in very rare situations like national security can these principles be avoided. Let me give you a simple example here. Suppose a student is accused of misconduct. Can the college rusticate him immediately without asking anything? Obviously, it should not. The student must be given a chance to explain. This is what the natural justice is all about. So, don't think of natural justice as something complex. Think of its fairness before punishment. Now, let me align this clearly with slide. Natural justice means principle of fair procedure. It includes the right to be heard and absence of bias. Its purpose is to ensure fairness in decision making. Now let's go to the fourth question, that is preamble of the Constitution. Before going into any legal meaning here, think of preamble like this. So what is preamble means? It is the introduction of the Constitution. In simple, whenever we open a book, right, we first read the introduction to understand what the book is about, who wrote it, and what it aims to do. In the same way, the preamble plays exactly in the Constitution. The first and most important line is "We, the people of India." We need to remember this, it's very important. The preamble means "We, the people of India." This line itself tells us something very powerful. It means the Constitution does not get its authority from the king or from the parliament or from the government. It gets its authority from the people, from us. Then the preamble tells us what kind of country India wants to be. It talks about justice, liberty, equality, and fraternity. We need to remember these four things, okay? Justice, liberty, equality, and fraternity. These are not just decorative words, these are goals that the Constitution wants the state to achieve. Even though the preamble is not enforceable by itself, it plays a very important role in understanding the Constitution. So, whenever there is a confusion about the meaning of a provision, court looks at the preamble to understand the intention behind it. In that sense, the preamble acts like guiding light. It shows the direction in which the Constitution must move. Now let's connect this with what is written on the slide. The preamble is the introductory part of the Constitution. It reflects the philosophy and objectives of the Constitution. It contains the core values like justice, liberty, equality, and fraternity. It also helps in constitutional interpretation. Now let's go to the next question, that is habeas corpus. This is one of the most important concepts when we talk about personal liberty. The word habeas corpus may sound heavy for us, but the idea behind it is very simple. Habeas corpus literally means to produce the body. What does that mean in practical terms is, it means that if a person is detained or arrested, the authority must justify that detention before the court. In simple words, the court asks a very basic question over here. Why is this person being kept in custody? If the authority cannot give a valid legal reason about the person arrested, the court orders the immediate release of that person. Habeas corpus exists to make sure that no one is secretly, illegally, or arbitrarily detained. Another very important point that we should remember is this: the writ of habeas corpus can be filed not only by the detained person but also by any other person on his behalf. So, if the person here is detained and is not able to writ the habeas corpus, the person B, relative of person A, still can file this habeas corpus to court. This makes a very strong protection against misuse of power. Now let's think about it in this way. If the police had unlimited power to detain people without explanation, personal liberty would become meaningless. Habeas corpus ensures that liberty is protected and that the state is always answerable to the court. Let me give you a simple example. Suppose a person is arrested without following a legal procedure or is not produced before a court or a magistrate within the required time. In such cases, habeas corpus can be used to secure his release. Now let us align this with the slide that is written. Habeas corpus means to produce a body. It is a writ issued to protect legal personal liberty. It is used to against illegal detention. It safeguards the right of life and personal liberty under the Article 21. Now let's go about the next question, that is state emergency, which is also commonly called President's Rule. First, understand one thing clearly here. State emergency is not about day-to-day political problems. So we might be seeing in every state, right? The political problems will be keep arising day by day. But state emergency is something different from that. So state emergency is a serious situation where a state can be run according to the constitution. The constitution provides for state emergency under the article 356. We need to remember this article 356 here. And using this, when there is a failure of constitutional machinery in a state. What does that mean in simple words? It means the elected state government is unable to function as required by the constitution. When state emergency is imposed, the state government is dismissed. The governor runs the state on behalf of the president. The legislative powers of the state go to the parliament. So effectively, the center take over the administration of the state. This provision exists to ensure that the constitution is respected even at the state level. However, because state emergency was misused in the past, right? Courts now closely examine whether it has been imposed properly. The idea is not to remove governments for political reasons but to protect constitutional governance. Let me give you a simple example on this. Suppose after elections, no political party is able to form a stable government and there is complete administrative breakdown. In such a situation, president's rule will be imposed. Now let us look at what is written on the slide. State emergency is imposed under Article 356 of the Constitution. It arises due to the failure of the constitutional machinery in a state. It is also known as President's Rule. Under this, the President takes over the administrative of the state. If you remember these points clearly, you can answer any question on state emergency confidently. Now let's look at seventh question, that is financial emergency. This is often confused with state emergency, so listen carefully over here. Financial emergency has nothing to do with failure of the government or politics. It is purely about the financial condition of the country. The constitution provides for financial emergency under the article 360. Whereas in the previous question we look at the article 356, that is state emergency. Here for financial emergency the article is 360. It can be proclaimed when the financial stability or credit of India is threatened. In simple words, right, when the country faces a serious economic crisis and normal financial control is not enough, the financial emergency can be declared. When financial emergency is in force, the center gets greater control over the finances of the states. Salaries of government servants, including judges, may be reduced and strict financial discipline is enforced. The idea behind this provision is to protect the economy of the country during extreme situations. However, financial emergency has never been imposed in India till date. This is a favorite point for examiners. Let me give you a simple example to understand the idea under the idea about the financial emergency. Suppose the country faces an extreme financial collapse affecting national credit and economic stability. In such situations, financial emergency may be required. Now let's look at what is written on the slide. Financial emergency is imposed under the Article 360. It is declared when the financial stability of the country is threatened. So when the financial emergency is imposed, the central government can control the state finances. Now let's go to the next question. That is eighth question, federalism. This is one concept where we often memorize definitions but don't really understand how it works in practically. So let us start with very simple. Federalism means a system where power is not concentrated in one authority. Instead, power is divided between two levels of government, that is the central and the states. So basic idea of this is a country is too big. As we all know, India is too big and too diverse. to be governed from one place alone. That is why in India we have both national interests and legal interests. Federalism allows both to exist together. Now India follows what we call is a quasi-federal system. That means it is federal in structure, but the center is strong than the states. The constitution clearly divides powers through three lists: the union list, the state list, and the concurrent list. Some subjects are national importance, so they are given to the center. Some are local importance, so they are given to the states. And some subjects need to cooperation between both of them, so both can make laws on them. An important point to remember is that the judiciary plays a key role in maintaining federal balance. Whenever there is a dispute between the central and the state government, courts step in to resolve it. This federalism also helps India manage diversity, different languages, different cultures, different regions, and can function independently while still remaining united. Let me give you a simple example. Defense and foreign affairs are handled by the state, by the center, by the center because they concern the entire country. But police and public order are handled by the state because they are local matters. Now let us see what is written on the slide. Federalism means division of powers between the center and the states. India follows a quasi-federal system with a strong center. Powers are divided through union, state and concurrent lists. An independent judiciary maintain balance between center and the states. Now let's talk about state. Ninth question under Article 12. This is a very important question because in constitutional law the word state does not mean only state governments. In ordinary language when we say state, right, we think of states like Tamil Nadu, Karnataka, Maharashtra, Andhra or any other state in that matter. But constitutionally the meaning is much wider. Article 12 of the Constitution defines state for the purpose of enforcing fundamental rights. Why is this wide definition necessary? Because of only governments were considered as a state, many authorities exercising public power would escape responsibility. So Article 12 includes not only the government and legislature but also local authorities and other bodies that perform public or governmental functions. The idea in this is very simple. Anyone who has the power to affect public rights should be accountable under fundamental rights. This wide definition ensures that fundamental rights are not just theoretical but actually enforceable in real life. Let me give you a simple example here. Municipal corporations, electricity boards, or government controlled authorities may not be traditional government departments, but they exercise public power. That is why courts treat them as state under the Article 12. Now let's look at what is written on the slide. State has a wide meaning under Article 12 of the Constitution. It includes government, legislature, and authorities. This wide definition helps in effecting enforcement of fundamental rights. The last question and very important, center and state relations. This topic helps us understand how India actually functions a day-to-day basis. India is a large and diverse country. We have one union government and many other state governments. If there is no clear understanding of what does what, governments will become chaotic. Central state relations deal with the sharing of the powers and responsibilities between the union and the states. These relations are not meant to create conflict, They are meant to ensure coordination and cooperation. The Constitution carefully divides these relationships into different areas. That is, some powers relate to making laws, some relate to administration, and some relate to money and finances. Legislative relation decides who can make laws on which subjects. Administrative relation decide how the center and state helps each other. Finance relations decide how revenue is shared and how grants are given. All this is done to maintain a balance. The center must be strong enough to maintain national unity, and the state must be strong enough to manage local needs. Instead of constant struggle of power, the Constitution promotes cooperative federalism. For example, the center collects certain taxes and then shares revenue with the states. Similarly, the center gives grants to the states for development and welfare schemes. Now let us look at what is written on the slide. Center-state relations refer to the distribution of powers between the union and the states. They include mainly three: legislative, administrative, and finance relations. Their objective is coordination, cooperation, and national unity. If you understand these center-state relations in this manner, we can easily handle both short and long answers in exams. If you found this video helpful, please subscribe, like, and share with your fellow friends. Thank you for watching.